If you've ever been through a legal challenge, you definitely know the feeling. You sit through the whole process, you get a formal judgment, and you're just left with this sinking suspicion that something went, well, fundamentally wrong.
Hmm.
Not just that you lost, but that the outcome feels, incorrect or maybe unfair or both. It's so frustrating.
It is.
And the first thought is always, I have to fight this. I need to appeal.
And that desire for redress it's completely valid. The legal system, especially here in South Africa, is designed to accommodate human error.
Yeah.
But seeking that remedy requires a certain precision.
Okay.
The real challenge isn't just about fighting the judgment. It's about identifying the specific type of error that actually occurred.
Yeah.
You have to ask, did the court get the answer wrong, or did it break the rules while it was trying to find the answer?
And that is the absolute core of what we're diving into today.
Mhm.
Our whole mission here is to unpack that critical difference between an appeal and a review.
Right.
There are two legal pathways that people often confuse, but they target two entirely different forms of justice. You've got substantive justice, so did they get the core outcome correct?
Yeah.
Versus procedural justice. Was the entire process fair and, legally sound?
Getting this distinction right is not just some legal formality.
Yeah.
For you, the listener, it's a matter of immense practical and, frankly, financial importance if you ever find yourself seeking that redress.
Because if you pick the wrong door...
You waste time, you waste money, and a lot of emotional energy arguing the wrong point in front of completely the wrong court.
Okay, let's unpack this then, starting with the appeal. I think this is the one most people are kind of familiar with. You lost, so you appeal. What's its fundamental mission?
So the appeal is laser-focused on substantive justice. Its goal is purely to determine whether the previous court's decision was legally and factually correct.
Right.
You're basically arguing that based on the evidence that was already presented, the law was misapplied,
Right.
or maybe the court just made a clear error in how it interpreted the facts.
So we're not interested in the judge's behavior at all here. We're looking at the final product, the merits of the case itself.
Precisely. To use a simple illustration from the material we looked at, let's say a court incorrectly interpreted a clause in a contract.
Okay.
Maybe they decided A meant B when any reasonable legal reading confirms A actually means C. That mistake is an error of legal misinterpretation.
It's right there in the substance.
Exactly. So that challenge goes to the very substance of the decision, and for that, an appeal is the only route. You're arguing the original judge simply got the law or the facts wrong.
And crucially, when you go on appeal, you are taking your case to a higher court. So how is this transfer of accountability handled? Are you just starting over from scratch?
Absolutely not. And that brings us to a really critical detail. Appeals are governed by very strict statutory frameworks. We're talking about the Superior Courts Act of 2013 for movements, say, from the High Court up to the Supreme Court of Appeal.
Right.
And the Magistrates Courts Act for the lower tribunals.
And these statutes, they ensure that the appeal focuses almost exclusively on the record of proceedings from the lower court. Why is that reliance on the record so strict?
It defines the entire process. When you launch an appeal, you are not relitigating the facts. You're not bringing new witnesses.
So you can't add anything.
Nothing. You're effectively holding up the transcript and saying to the higher court, look at the evidence and the law that was presented to the lower judge. They had all this information, and yet they still came to the wrong conclusion.
So if I suddenly find a brilliant new piece of evidence, something that would have won my case, an appeal is generally not the place to present it.
That's exactly right. That new evidence is typically excluded. The appeal court is reviewing the work that was done by the lower court judge, which means they limit themselves to the four corners of that record.
So they're just checking the math.
You need to show that the initial judge, based on what they already had, made a reversible mistake. You're checking the existing work, not, submitting new assignments.
That sets a very, very clear boundary for the appeal pathway. Focus on correctness. Focus on the record. Now, let's pivot to the review pathway, because this is where the conversation shifts entirely from what the answer was to how that answer was reached.
And this is where we move from substantive justice to procedural justice. If the appeal is about, say, the quality of the final painting, the review is about whether the artist followed all the safety rules and didn't use, contaminated materials during the process.
I like that analogy.
The goal here is to address concerns about the procedural legality and the fairness of the whole decision-making process.
So the outcome could theoretically be the right one, but if the process to get there was fundamentally tainted, the decision can still be set aside through a review.
Exactly. We're scrutinizing the adherence to proper procedures, the legality underpinning the entire process. The error here isn't that the judge got a contract wrong. The error is that the magistrate or administrative decision maker engaged in conduct that was riddled with gross irregularities.
Okay, gross irregularities.
Or acted with bias, or just completely exceeded the scope of their legal authority.
That's a serious accusation. I mean, it's a challenge to the system's integrity itself.
Yeah.
What legal frameworks govern this process? It seems broader than just the courts.
The framework comes from a couple of places. It's rooted in common law, so the inherent power of the High Court to oversee lower bodies, and critically, from specific legislation. The most prominent one for reviews of administrative actions is the Promotion of Administrative Justice Act of 2000.
PJ.
PAJA, exactly.
And PAJ is the tool we would use when challenging a decision made by, what, a municipal official or some government board.
That's right.
So what are the telltale signs, the ones listed in PAJA, that should scream reviewable error to you, the listener?
The grounds are quite extensive, but they really boil down to a failure to act legally or rationally. So you're looking for things like bias, procedural unfairness, like not giving you a chance to respond, or actions taken entirely without proper authority.
And irrationality, right?
Yes. And perhaps the most compelling ground is the challenge of an irrational decision. This is a decision that is so wild, so unreasonable, that no person who was properly applying their mind could have possibly arrived at it.
That sounds like a pretty high bar to clear.
It is.
So if the magistrate in a lower court is the one committing the irregularity, not an administrative official, do we still use PAJA? Or does the Superior Courts Act come back into play?
That's a very good question. When you're reviewing the conduct of the Magistrates Court specifically, the Superior Courts Act actually provides 4 very specific grounds for review, and they all relate to the judicial officer's actions. These are procedural cornerstones.
Okay, let's detail those. I feel like this list is essential for anyone dealing with a magistrate's court judgment.
For sure. So, first one, absence of jurisdiction. The court simply didn't have the legal right to hear the case in the first place.
Simple enough.
Second, interest in the cause, bias, malice, or corruption on the part of the judicial officer. That is the clearest sign of a complete procedural breakdown.
And that second one is a huge distinction from an appeal, isn't it? If I appeal, I'm saying the judge made a bad call. If I review on this ground, I'm saying the judge was tainted.
Precisely. The judge was tainted. What are the last two?
The last two. Third is a gross irregularity in the proceedings. This is a bit of a catch-all for any severe process failures.
Right.
And fourth is the issue of admissibility of evidence, specifically the admission of evidence that shouldn't have been allowed, or the rejection of evidence that was perfectly competent and should have been heard.
Now, wait a minute. Doesn't rejecting evidence, doesn't that sound like an appealable factual error? If a judge rejects my best witness, that feels like a mistake on the merits of my case. Why is that a review ground?
That is the subtle distinction that really defines the separation between these two paths. When you appeal a rejection of evidence, you argue the judge mistakenly decided the evidence wasn't weighty enough.
A mistake on the merits. Okay.
But when you launch a review under that fourth ground, you're arguing something different. You're saying the judge committed a procedural irregularity by refusing to even consider competent admissible evidence, or, on the flip side, allowing evidence that was legally barred. It's about the technical rule of admissibility being broken, not about the weight that was eventually given to the facts.
So it's about whether the judge followed the proper process for deciding what information was even allowed into the case. I see. The integrity of the rules themselves is the target.
Exactly. And if we focus on that idea of gross irregularity, the material pointed out one specific rule that is truly a cornerstone of our law, and that's disregarding the auditorem partem rule.
Which in plain English just means the rule to hear the other side.
Precisely. This rule is absolutely fundamental to procedural fairness. If the presiding officer just cuts off one party's right to present their evidence or denies them a chance to argue their case entirely, that is a gross irregularity.
The fairness of the trial is just gone.
It's compromised at a level so basic that the entire structure of the proceedings just collapses. A review is required because that lack of fairness comes before any final decision can even be made. You can't have a legitimate judgment without a legitimate process.
Okay, so we've established a really rigid separation here. Appeal is for correctness. Review is for procedural integrity, especially when you're dealing with magistrates courts or administrative bodies.
Right.
But what happens when we talk about the highest level, the high court? We can appeal a high court decision to a higher court, sure, but can we review the proceedings of the high court itself?
This is where there's a fascinating structural twist in the system. And the answer is a very firm no.
No.
There is no provision for the proceedings of a high court to be reviewed by a higher court, like the Supreme Court of Appeal, in the same way you'd review a decision from the Magistrates Court.
That seems counterintuitive. If a high court judge displayed blatant bias, which is a classic review ground, you're telling me I can't file a review.
Yeah. You can't file a separate review application focused only on the procedure. This is where the two pathways actually merge. If grave irregularities or illegalities happen in the high court, including bias or procedural unfairness, the remedy is to include those procedural failures in the appeal itself.
Wow, that's fascinating. So at the high court level, a procedural error gets treated as just another type of legal error that you appeal, rather than a whole separate procedural challenge that you review.
It speaks to the fundamental presumption of regularity within the higher levels of our judiciary.
A kind of built-in trust.
The system basically assumes that high court judges are adhering to proper procedure, and if they fail, that failure is treated as a ground for appeal, a reason why their substantive decision should be overturned, rather than demanding a whole separate legal action to challenge their conduct.
Okay, let's bring this all home for you, the listener. We started with that feeling of frustration after an unfavorable judgment. Now we have the tools to analyze why that judgment feels so wrong.
And the essential takeaway is still this. Before you file anything, you have to classify the error. The appeal is your rote if you believe the court just erred on the substance.
They misinterpreted the facts or the law on the record. It's a challenge to correctness.
And the review is your path if you believe the court erred on procedure. The presiding officer was biased, they exceeded their authority, or they failed to stick to the cornerstones of fairness, like the rules in PIGA or the rules governing the magistrates court.
That's a challenge to legitimacy.
And understanding that distinction is invaluable. It's what transforms a vague feeling of injustice into an actionable, targeted legal strategy. It makes sure that justice, in both its substantive and procedural forms, is upheld.
We've really clarified two massive legal concepts that, let's be honest, are often blurred together by anyone outside the legal field. It's a complex structure, but the underlying logic is incredibly clear once you know what you're targeting.
And if we connect this to the bigger picture, the whole structure of our judicial system, maybe consider this final thought. Since a procedural failure, like blatant bias in the magistrates court, warrants a wholly separate review application, but the exact same failure in the high court gets absorbed into an appeal. What does that difference tell you about the fundamental trust and accountability that's placed in the proceedings of higher courts versus lower courts?
It suggests the system applies different standards of oversight based purely on judicial seniority.
It certainly gives you something to mull over regarding the hierarchy of our courts. And as we always remind you, while we've distilled this information from our source material, this deep dive is for informational purposes only. It does not constitute legal advice.
If you are facing this exact dilemma, the golden rule remains the same. Consult an attorney.